Hello and welcome to this Maritime London webinar in partnership with HFW. I'm Jos Standerwick, Chief Executive of Maritime London, and I'll be moderating today's briefing and discussion on the UK's Economic Crime and Corporate Transparency Act. I think we only have an hour, so in the interests of time, I may refer to it as the ECCTA from this point forward. The ECCTA received royal assent on the 26th of October 2023, and I think it may be fair to say it's gone a little bit under the radar in shipping circles, which of course is highly understandable given the slew of regulation and compliance issues that the industry has had to face over the past 24 months. However, I think as we will discuss today, the ECCTA does represent a significant shake-up when it comes to corporate criminal law. As we will talk over the next hour or so, I think the two most significant changes will be the introduction of a provision to fail to prevent fraud and the placing a statutory basis on the corporate identification of a principal. From an observer's perspective, and I'm in no way an expert, given the complexity of the shipping value chain and the corporate structures that exist within our industry, I think this is something that the market certainly needs to comprehend and take the appropriate steps to mitigate any potential risk. Joining me in this discussion today, we have a man in shipping circles who needs very little introduction, but in the interest of good manners, I will provide one. Paul Dean, who is head of global shipping at HFW. And I'm sure in global investigations and white-collar crime, Barry, you hold a very similar weight, but also Barry Vitou, who is head of global investigations and white-collar crime at HFW. Before we get started, I'll just run through some housekeeping. The session is being recorded, and a recording of the session will be sent to all of those who have registered today. You can ask any questions in the Q&A tab, which I will do my best to weave in to the discussion as and where appropriate. And last but not least, we are live today, and we very much hope that there will be no technical glitches. If we do have any issues, please do bear with us. Right, so I think without any further ado, Barry, I will pass over to you, and Barry's going to provide us with an overview of the Act. So Barry, over to you.
Thank you, Jos. And hopefully one of my colleagues is going to, yes, there we go, the slides have just popped up on the screen. So no, thank you for that introduction, which was very, very helpful. And just picking up on one of the things that Jos said, it's correct. I mean, there's obviously been lots going on in the industry over the course of the last couple of years. So unsurprising that this might have been not picked up in all the other noise that's been going on. I've also seen that there has been some reference, certainly in the shipping press, that this has been referenced as being something that might relate, is relevant to, say, the oligarchs and stuff like that. That is not the case. This is sector and corporation agnostic. I understand why it may have been misconstrued in the media in that way, because it's a piece of legislation which was incorporated and finally passed in an act which went through in a bit of a rush, to be honest, in the wake of the Russian invasion of Ukraine. But this particular legislation has been very long in the works. It's been subject to various parliamentary reviews, calls for evidence and all the rest of it, and has been incorporated on the omnibus that is the ECCTA, or ECTA, as I've dubbed it. So it's a very lengthy piece of legislation, but we're going to focus on two things, as Jos said here today, and they are basically game changers when it comes to the attribution of criminal liability to companies in the context of fraud. And some of us will remember back in 2010 and 2011, there was a big hullabaloo about the attribution of corporate criminal liability in respect of bribery. And we have seen a number of large cases go through in the intervening period in relation to corporations that have reached a resolution in relation to corporate bribery over that period. And this represents another piece of the same sort of jigsaw puzzle, which I have dubbed over the years as being sort of the continuing sort of criminalisation of corporate law in the UK, but also elsewhere. So two things I want to pull out of this legislation from that perspective are as follows. Next slide, please. So corporate attribution for economic crime, or how can you pin criminal liability on a company? Obviously, this is a tricky topic, largely because, of course, a company in and of itself can't do anything. It's just a set of corporate books. It's other people that trigger liability for it through either their actions or omissions. and it's been something which, in the context of UK criminal law, has caused significant problems over the years. The law has therefore evolved to deal with these problems in a sort of phased way. And some of us will remember the sort of introduction of corporate manslaughter legislation. I've already talked about the legislation that's been enacted in relation to bribery, which was, coming up to 15 years ago now, been in place for a while. We've had similar legislation in relation to tax evasion and now fraud. So there is now sort of a long-standing trajectory of the imposition of corporate liability for criminal conduct in the UK, which reflects a broader global picture, which we might touch on a bit later. Next slide, please. So how did we get here? As I said earlier on, this thing has been batting around now for quite some significant time, and various sort of parliamentary reports, etc., about it. I think the real catalyst for change was really the fallout from the global financial crisis, and in particular, I think the Barclays case, which probably some of us will have read about in the press a few years ago. Just to cast our minds back a little bit, in the financial crisis, Barclays went off and got some financing from an external financier, and there were allegations. They were one of the few banks that did not seek government bailouts, and they issued a prospectus, and it was said that there were material omissions, and so that prompted an investigation by the Serious Fraud Office, who in turn sought to charge the company Barclays Bank itself and a number of very senior executives, including John Varley, the CEO. I should preface all of this by saying that, of course, at the end of the day, those that were finally tried in court were found not guilty. But the principle remains the same. They wanted to charge Barclays and they wanted to prosecute Barclays in court. And they thought, I think, they were on a bit of a home run on that one in terms of the ability to do it, i.e. bring Barclays to court, on the basis that John Varley, the CEO, was also somebody that they alleged had been involved in all of this. And actually, after some legal wrangling and trips to the Court of Appeal, it was held that no, notwithstanding that you say that John Varley, the CEO, is involved, and you want to charge him, that's not good enough here. It's not good enough that the CEO you say was involved in all of this. That on the facts of this case, that doesn't mean that you can charge Barclays as well. And so I'm afraid that was really the watershed moment. People said, well, hang on a minute. We can't have a situation where the CEO of a company is alleged to have been mixed up in something, and we can't go after the company because that person was not, on the facts, the directing mind and will of the company in relation to this issue. So that's how it all started. And it's driven these two changes. I'm going to kick off with the first one that's already in force as of Boxing Day, 26th of December 2023. And basically, you can see there that I've produced the sort of the most relevant section. But basically, it says that it's attributing criminal liability for companies or partnerships, the organisation, if a senior manager of that entity acting within their apparent or actual scope of authority commits a relevant offence after the section comes into force. So this is already in, and it applies extraterritorial in certain circumstances. It is expressly stated to include sort of overseas companies, but of course there does have to be some nexus with the UK, and I think when we look at this, there will be some limitations, but broadly speaking, if the overseas element is this, that where a relevant body is liable to be proceeded against for an offence under this section, then if I'll just turn it up because it may help. Let's have a look if I can find it. But basically, if it's an offence in the jurisdiction where the act took place, then it will also trigger an offence here. So if, for example, a company commits an offence which would be fraud in the UK but was perfectly lawful where it took place, that won't be triggered. But if it was an offence in the jurisdiction where it happened, then it will be potentially covered. So there are, obviously, as I've said, there are some limitations to this, which we can touch on, I think, a bit later with questions, and if anybody has questions yet. But the point here is that it provides for an element of extraterritoriality, which is a big change and obviously a risk for companies, and it is in force already. Next slide, please. So who is a senior manager? This is a fairly, for those that have worked with the corporate manslaughter laws on the call, this definition will be one that's relatively familiar. It is important to keep in mind that this is broader than directors and officers. So you may recall that I mentioned in passing that historically it's been thought under the old test that you basically needed a director to be involved. But here, this is a senior manager. And a senior manager may not necessarily be a director and officer. And this gives rise to a sort of practical tip or recommendation at this point that I'll just throw out there, which is that if there is a problem, and we would typically recommend that individuals that are in the crosshairs of allegations of misconduct are properly advised, and typically they will trigger their D&O policy to get some legal advice. It may well be the case that existing D&O policies do not cover senior managers. And so my sort of an initial tip here, practical tip, would be in the wake of this particular new offence, and also the offence that we're going to go on and touch on in a minute, that existing D&O policies are checked to make sure that those individuals that are contemplated as being those who can trigger liability for a company are also able to avail themselves of D&O cover or insurance cover if it turns out that they come under the spotlight. So next slide, please. The relevant offences under this section are quite broad. I've included these ones down here, but you can see there's quite a few. There's a lengthy schedule in Schedule 12 which goes beyond this. Some of them are going to be quite specific from a UK perspective. So, for example, if you have, I'm not sure it's on this list, but if you're cheating the public revenue, that would typically, that's a tax offence. That's very UK specific. But others you can see may have slightly broader application, and we'll look at that on a slide with a couple of examples in a moment. But the key point to note is that there's a lot of offences in here, and I'm mindful of time and that there may be some questions that people want to raise. So moving on to the next slide. So we put in some examples on the screen, which could be examples of the sorts of offences that I've just referenced. So fraud by false representation. I won't read all the words on the slide, but basically somebody over glosses or gilds the lily in relation to a service or a product that they are selling. And I looked at two. We can see, for example, that at the moment there is lots of focus on the sorts of statements that businesses or some businesses are making in relation to their environmental credentials. And sort of a feature of that, I think, has been to date that largely those sorts of statements have been driven by marketing departments without involvement of legal. And so, and we also know that there are various claims, mostly in the criminal sphere at the moment, in relation to the sorts of claims or statements that are being made. But if it were the case that somebody enters into an arrangement, a contract on the basis of a false representation, then that would be or could be something that would trigger a liability for a company under this. If it was a senior manager that made the representation, company could be on the hook for it from a criminal perspective. Likewise, false accounting, we've talked about reference here, bills of lading and certificates of origin, for example. And then item 2, hiding debts, we would be pretty familiar with that one. False liability lading, for example, to obtain financing from a London bank, that could be an example, with losses suffered in the UK. Likewise, we've got the example there at the far end, the sort of breach of sanctions regulations as well, which we'll all be relatively familiar with, I'm sure, in the wake of 2 years of that particular new development. So next slide, please. So this is really just to underscore which way the direction of travel in relation to all of this. That, as Paul mentioned, or Jos mentions, I should say, this new act was passed, I think, in October 23. Within weeks of it being passed, there is now a new bill which is still going through Parliament, which will broaden out the lists of offences that this applies to, presently included in Schedule 12 of the Act, and limited to the fraud offences, to any offence. So, that legislation is also included in an omnibus piece of legislation that looks like it will go through before any election, as being sort of manifesto or sort of manifesto type commitments or election type commitments, or things that would have happened by the incumbent government. And so, for example, to give you an example of the breadth of this particular bill, you may have read within the course of the last week or so in the UK, if you've been picking up the UK news, that there's been some controversy about criminalising homelessness. Well, that the law that relates to all of that is also included in this Omnibus Act, and the present government's keen to get that and other similar provisions through Parliament before the election. So I think we could see this change happening quite imminently. Next slide, please. So on top of the sort of the change to the law from a Barclays perspective, we've also got the new failure to prevent fraud offence, and I touched on this at the beginning. We may recall that 2010 came into force in 2011. There was the failure to prevent bribery offence that was enacted. failure to prevent fraud is basically a cookie cut with a few minor changes to the failure to prevent bribery offence, but now enacted to encapsulate fraud offences. Oddly, slightly fewer fraud offences than those in relation to the corporate attribution offence, but nevertheless, for present purposes, I think for those on the call, the differences between the two will be largely academic, certainly in the context of a webinar of the duration that we've got today. So, failure to prevent fraud offence, very similar to failure to prevent bribery offence. Next slide, please. And I've put up the key provision there, so which will be familiar to many in the context of bribery. So, relevant body, which is a large organisation, and we'll look at the thresholds of what constitutes a large organisation at the moment. But for many, that will be a sort of fairly academic criteria that's imposed. Is guilty of offence if in the financial year of the body, whatever, a person who is associated with the body commits the fraud offence. And so you'll recall that I said at the top, that of course companies are inanimate objects, so it's other people that trigger liability for them. And here, the associate, if you look at the definition of associate, it will include employees, agents, the sorts of people, frankly, who we were looking at in the context of bribery. It's a very similar cohort that forms the associate here. Next slide, please. Again applies extraterritorially. Next slide, please. So I said I would touch on large organisations. You've got to hit two out of three for these. You can see that for many large corporations, that they're going to trigger this, and it picks up groups as well in section 202. So it's going to be. I'll just read them out just in case you can't see. Turnover, 2 out of the 3. The 3 criteria are for large organisations: 36 million or more turnover, balance sheet more than 18, and more than 250 employees. Parent companies, slightly different, but again, you can see that for many sort of largest groups, that they will be captured, will be captured by this. Moving over to the next slide, please. Associated person, just to really recap what I'd said before. So employees, agents, subsidiaries of large organisations, other people who perform services for or on their behalf, which is again, for those that sort of thinking back to the Bribery Act, again, very, 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 very similar. Assessment of whether a person is associated, relevant circumstances, the usual lawyers sort of, depends on the facts type answer. But I think we are relatively familiar with the concept of an associated person now. Moving on to the next slide. I said that there was a lesser list of offences for failure to prevent fraud, but here they are. But you can see that for all intents and purposes, the things that we would be concerned about, and I think we would recommend why we recommend that clients are familiar with these 2 new offences and consider their application to them and what steps, if any, they need to take as a result. These are all things that we would be concerned about, and I would also sort of just reference back to my examples, the 3 examples that I gave earlier. Without, I don't want to sort of go over old ground, but you can see that these are going to capture many of the scenarios that we would be concerned about in a corporate context anyway. Next slide, please. So the defence, so again, this is all sounding like fairly old, familiar territory. Just like the Bribery Act, the good news on the failure to prevent fraud offence is that there is a defence. And just like the Bribery Act, if we all remember those days, there will be government guidance which will be published about reasonable procedures to prevent fraud. That guidance is not yet published. when it is published, that will start the clock on the coming into force of the new failure to prevent fraud offence. So this one not in force yet, but again, I remind that the corporate attribution offence is already in as of Boxing Day, and in broad terms, the reality in what we are saying to clients is that actually, the same principles around defence apply to both offences. Why is that? When the corporate attribution offence doesn't have a defence, well, in the real world, if you have a company which is being pursued for corporate the first offence that I talked about, rather than this one, you're going to want to deploy the defence and all the steps that you took to prevent that from happening in the first place, to trigger the prosecutor to not pursue you. And just to sort of put a bit of overlay on that, when a charging decision is made, there are two basic tests that the prosecutor is going to look at. They're going to assess, one, whether the facts are there or sufficient that they think that they have a good chance, a more than 50% chance, for want of a better sort of description, that they may get a conviction. And then there is a second test that they're going to apply, which is going to be the public interest test. In all the circumstances, does it make sense in the public? Is it in the public interest to bring this prosecution? And when we are challenging or seeking to dissuade a prosecutor from making a charging decision against a corporate client, which we do, then we will be relying heavily on their compliance program. So though it's not written into statute that there is defence, in practical terms, there is certainly a good opportunity to make what we call those representations to dissuade a prosecutor from bringing a charge in the first place, which of course is what we want. We do not want our corporate clients charged with offences of criminality for obvious reasons. So I would say that it's good to be thinking about this now. In terms of what the guidance is going to say, there was an advanced draft in circulation and being circulated to various different bodies. I've seen a copy of it as a result of one of the committees that I sit on. I'm embargoed from sort of saying all the detail that's in there, but I can say this, which is there are no surprises. And if you were to look at the existing, so the sorts of the high-level principles that we've flagged in red on this slide, then again you will be reminded, no doubt, of the anti-bribery sort of high-level principles that existed and still exist in relation to the failure to prevent bribery offence. The issue is that the sorts of checks and controls, bribery is a discrete criminal offence at the end of the day, so perhaps easier to identify the sorts of controls and DD that you might need in the context of bribery, whereas fraud is a much broader church of potential issues which need to be considered, for example, in the context of a risk assessment and then controls and due diligence, etc., etc. So we would say, or we are recommending to clients that they should be considering the existing compliance environment that they've got that deals with, it's going to deal with all sorts of things, isn't it? It's going to deal with your sanctions, it's going to deal with your bribery, it's going to deal with all sorts of things, and it needs to be dusted down, looked at, and potentially refreshed in the context of the new failure to prevent fraud offence, and also the already in place as of Christmas last year liability, corporate attribution liability. Next slide, please. If there is a next slide. Thank you. So what should companies be doing to prepare? The $1 million question. And I've touched on this already a little bit. So if we just flip on to the next slide. Okay. first of all, I have already flagged, it's not actually on this slide or in the deck, but a basic thing that everybody should be doing at this stage is looking at D&O cover to make sure that it is enough to cover the new people that are likely, and in particular senior managers, that can now trigger liability for criminal liability for companies. Now, those individuals themselves, from a technical legal perspective, the law in relation to the underlying criminal act, so to speak, so whether it's one of those fraud offences that was on the screen just now, that law hasn't changed. It remains the same. So you might say, well, why do we need to do anything with those people? Or why do we need to worry about that then? And the answer is, well, as we've now talked about at some length on this call, that can trigger liability for the corporation, and in those circumstances, the company will want those people to be properly advised. Well, we would certainly always recommend that, because that's going to be far better than having somebody make a mistake and then finding that they've inadvertently triggered a sort of an auto liability for the company. And the second thing is that the risk profile of those individuals and their understanding of what these things all mean and making it relevant to what they do on the day-to-day basis, they probably haven't thought about it. Have they thought about, what the bar is for fraud by false representation, for example? Probably not. The other thing to mention is that we all know, and so I'm just going to meet this head on, that law enforcement in the UK, but it's a global phenomenon, is cash strapped. And so the incentive for law enforcement to go after senior managers involved in fraud, I mean, often their retort would be, this is a civil matter, you should deal with this civilly. But that changes a little bit when you look at the potential pot of gold, to be cynical about it, that exists for them and government in circumstances where they can attribute liability to the company, but their gateway to get there is the individual. So the potential criminal liability sort of risk factor for individuals is now much higher than it was. And you have to look at all that in the context of what is there is a large focus on fraud at the moment. We've all seen sort of the headlines. There's a change of government in the offing, which I know has also earmarked sort of clamping down on fraud, and in particular corporate fraud, as one of the things that they're very interested in looking at. And so I think that the general risk profile to corporations in the wake of this legislation has increased. You've got the likes of the NCA and the Serious Fraud Office saying they're almost in a race to be the first to use the new legislation in the context of a corporation. They regard it as a significant addition to their corporate toolbox. So, so D&O, there is increased risk for individuals, and I think that we want to make sure that they are covered by D&O policy or insurance policy if they need help and advice in relation to these issues if they pop up. On the sort of corporate side, what we recommend, well, here really, I'm just going to risk assessment. I do think it's useful to look at, well, there needs to be a risk assessment. Without one, there will not be reasonable procedures. You will not have your mitigating factor to try to argue that it's not in the public interest to bring a charge, or an absolute defence in the context of the failure to prevent fraud. If you haven't got one, it's a basic requirement. So all of those need to be dusted down, looked at, and refreshed, making express reference to the new laws. I've talked about enhancing anti-fraud procedures. I've just touched on there on the screen, which I won't read out. I think this is going to be circulated among those who attended the webinar afterwards, so you'll all get it anyway. But you can see the sorts of things that we're recommending. Training, of course. And again, I think, at an immediate level, I think in making sure that senior managers are aware of the increased risks to them and the law that came in just after Christmas or Boxing Day. And then, of course, the top level and the mid-level commitment that we've all referenced before. So that's my sort of very quick canter through the Act, and in particular, really, the two new big things, which is the change in the corporate attribution rules, so the senior manager liability piece, and now also the, I would say, relatively imminent arrival of the new failure to prevent fraud offence, which has generic application to all companies, not just, as I have seen in the shipping press, to engage Russian oligarchs. If I get nothing else across on this meeting, it will be, please just be aware that this applies to everybody.
Barry, thanks so much for that really thorough overview. And Paul, good to see you back in the room. As we all know, best laid plans with webinars, etc. But at least you're here now. I think, Paul, if you're okay, I'm gonna come to you first and give Barry a bit of a break. As I mentioned in the introduction, shipping has been faced with a raft of compliance and regulation issues over the last 24 months, which perhaps the direct impact on the sector is more obvious than this particular piece of regulation coming out of the UK. And I suppose my question to you in that context is, historically, how has the shipping industry reacted to regulation that perhaps is not directly targeted at the sector?
It's a very good question. And I'm reminded of your point at the outset about tech issues, and I'm also thinking about worse things that happen at sea. I think that the shipping industry is very interesting. In fact, at the moment, I'm reading an excellent book by an economist called Philip Coggan, who's otherwise known as Bartleby. He writes in The Economist. The book is called More, and at the beginning, he talks about or writes about the history of the shipping industry and how it is an industry which has been around for literally thousands of years. And during that time, the industry has evolved with all sorts of eventualities that it's faced. As we bring ourselves forward to the modern day, Barry touched upon the Corporate Manslaughter Act earlier on in his presentation. But I think if we come even further forward in time, I'm thinking about the invasion of Ukraine. And as a result of that, there were a multitude of sanctions that were issued almost on a weekly basis in the early stages of the invasion. And given when we remember that shipping is, in terms of global trade, by volume, 95%, it had a massive impact on shipping. But nevertheless, shipping was able to continue. And I think in exactly the same way, whatever legislation or regulations come into force anywhere in the world, and we need to remember that shipping is truly global by nature, shipping evolves with it. And I see exactly the same thing happening in relation to ECTA.
Paul, thank you so much for that. And I think I just want to build on something that you were saying there, is the fact that, as you rightly say, shipping is as old as time, and as such, it has evolved in a very particular way. And of course, as you and I know, there is an entirely legitimate use of SPVs, etc., in the sector. And I suppose my question to both of you, are asset owners in the shipping industry in some way insulated from this legislation due to the use of SPVs? Barry, why don't I Paul, I'll start with you.
Well, I was going to just sort of, I think, re-emphasize that throughout my time in shipping and at HFW, SPVs are the norm. And they're there for very legitimate reasons. But then I think I would tend to stray into Barry's area in relation to personal responsibilities and piercing the corporate veil, that sort of thing. And perhaps Barry should comment in relation to that in the context of this particular legislation.
Yeah, I think that what this really is a broader point, but it underscores the importance of corporate governance around all of this. So I think the use of SPVs is commonplace, but it's important to make sure that when using them, they are treated as separate legal corporate entities, and that there is a sort of corporate governance setup and audit trail that shows that's exactly how they have been treated. If that is not the case, then you do run the risk that those vehicles become susceptible to either being pierced, or those people that are sort of treating them not in a way which is sort of involves good corporate governance, shall we say, expose themselves. So all the benefits that you're seeking to achieve by having an SPV go out the window, and that applies from both a criminal but also a civil perspective, because if something goes wrong and you have a counterparty or somebody who's not a counterparty who is looking to sue or go after people, they will be going after the deep pockets. And it may well be that the SPV probably won't be the deep pockets in the equation. And so they'll be doing everything they can think of, looking at the particular facts of the particular case to see if they can expand the cohort of defendants beyond the SPV. And so it's just really, really important that when you're dealing with them, that there are proper board minutes, that if there are directors, they are a functioning board of directors. It is not the case that somebody who is not a director is the only person who's also always calling the shots and telling the company what to do. In other words, becoming, for example, a shadow director and then exposing themselves to potential claims. So I would just say, and this, the two sections I've been talking about today, and compliance in general, Paul's mentioned various other things, are all part of that good corporate governance package when running your SPVs and or your businesses.
Barry, thanks so much for that. And just Paul, coming back to you there and just putting this into a bit of a shipping context again. I think it would be fair to say that corporate governance has risen up the agenda remarkably quickly within the shipping industry. We're seeing far more due diligence. We're seeing KYC and compliance teams build up significantly, both within law firms and within ship owning, or should we say companies within the shipping value chain. Do you feel that as a consequence of the legislation which the shipping industry has faced in recent years, we are as a market relatively well set for the introduction of ECTA?
Yes, I do. And I think I can remark upon that in a number of contexts. I think the first, and this in a way, this goes back to sanctions, and then as a result of that, the increase in KYC that is required of all of us. And I know it causes a number of frustrations for our clients, particularly on ship sale and completion, those sorts of things. And the regulatory side of things is so much more than I remember it many, many years ago. So when it comes to legislation like this, I think the industry is very well placed. I'm not sure it needs to do much more. And in terms of the supply chain, I think the industry is already very careful in terms of its due diligence, that the work that it does in terms of looking at its counterparties. And one thing that comes to mind is modern slavery, for example. All of us are acutely aware of who we're dealing with in terms of our third parties to make sure that we are not at risk, whether we're lawyers or whether we're ship owners or charterers or whoever we may be in the supply chain.
Paul, thank you for that. And I just want to delve into that counterparty piece in a bit more detail, and to build on something else you said there. Those of us who have been involved in sanctions legislation have got well used to the term UK nexus. And in the context of Hector and Barry, I'll come to you in regards to this. What is the UK nexus? And I suppose, to put it perhaps a bit more acutely, could foreign ship owners have an exposure to Hector through having a charter party arrangement with a qualifying counterparty, if that makes sense?
I think the short answer is yes. It's going to be very fact specific.
Yeah.
Okay. So you just to keep in mind how these offences work. So on the first offence I was talking about, the one that was brought in really to counter the Barclays problem, shall we say, that attributes the liability created by a senior manager, right, to the corporation. Now, there are some examples where I can clearly say there won't be liability, but frankly, there are lots of other examples, too many to list, where it would be a grayer zone, and it would, you'd have to. So, unfortunately, I can't produce the slide that says these three are in and these three are out, sort of thing. But you are going to, in the context of, let's say, the Barclays fix. Schedule 12 has a myriad of offences which I haven't all put up on the screen. Some of those will be domestic offences in circumstances where it's unlikely that there will be an extraterritorial element to it. But others, it's conceivable that they could have an extraterritorial effect. So a fraudulent conspiracy, for example, where there is loss caused in the UK off the back of a forged document, for example, in somewhere in all of that. You could trigger extraterritorial liability, right? And so I think the second offence that we're talking about, the cookie cut failure to prevent bribery offence, but in the context of fraud, is broader in its scope. But you are going to be looking for some degree of nexus. Right. So the question, if a client approached me and said, "Look, I'm a foreign ship owner, and that this has happened, and I want to know whether or not I have potential exposure," then I'm going to ask lots of questions about what happened. I'm going to ask lots of questions about what, as a matter of practice, happened with the UK nexus, and there's going to be an illegal analysis to try to work out whether what's happened is sufficient or not. That's the legal answer, right? The practical answer can sometimes be a different result. Okay, so there are lots of cases even today where there is a plain UK legal exposure, but for various reasons it doesn't manifest, because at the end of the day, the overseas exposure and interest from the local or overseas regulator is such that they take primacy, and the UK effectively steps back, but might collaborate with the overseas agent. So I know that's a sort of not a particularly helpful answer, save to say, which is my big takeaway about all of this, is that the position has markedly changed from a scenario where it was very, very hard to see any corporate exposure at all, whether extraterritorial or otherwise, to a position where that is no longer the case. The failure to prevent basically sort of expressly contemplates that there will be exposure. The definition of a company covered by it includes non-UK companies, for example, right? It expressly talks about, and both sections expressly talk about sort of offences overseas and things like that. So, which I don't want people to worry about any of this. That's not the purpose of this. The purpose of this is, one, to raise awareness, and two, to say that firms and ship owners need to be mindful of this and take there are a few steps which it would be worth them considering and doing, so that that they are informed about these things properly beyond a relatively short webinar, and then think about the question you've asked is really would really be something which you would factor into a risk assessment. Okay, this is how we're operating. These are the sorts of things that are happening in the context of the example that you gave. What do we think? Okay, there is no risk. Fine, we will move on. There is a risk. Okay, what steps should we take to ameliorate that risk? Let's make sure that our existing policies, procedures, controls, etc., cater for it. And then that's your defence, either practical or legal.
So I want to just build on something that Paul mentioned, and that's about the international nature of the shipping industry, etc. We see in terms of decarbonisation regulation, there is a lot of talk of equivalence, etc., with different jurisdictions. In regards to ECTA, does this represent a gold standard? Is it a step higher than we've seen from our friends in the US and the EU? Or does the US and EU have equivalent regulation, which I suppose much of the international market may already have to adhere to?
That's a very good question. So this does not represent the gold standard. You've got almost two polar opposites of the spectrum with the EU and the US. I mean, the US, you have federal laws, and you will have the position there in relation to corporate liability is I consider to be fairly extreme. Right, I think where the UK has come out on all of this is a much more sensible and real world approach. I mean, to paraphrase, apologies to any US lawyers that are on for now butchering the legislation in the US, but they have a concept in the US of respondeat superior, right? That means that anybody from the cleaning lady can trigger corporate liability for the corporation, okay? Which I think is absolutely crazy. The UK position does not have that. I mean, but keep in mind that the first offence I talked about, it talks about senior manager. That does not include the tea lady or the tea man or the tea person, whoever it is, right? So I think that's a far more sensible approach to who can trigger corporate liability for the EU is a different story because obviously it's not a federation, and when it comes to criminal law, it all has to be sort of implemented into individual member states. And when it comes to criminal law, that is not something which has been a principal focus. So when you go to the EU, what you find is a tapestry of different laws. What it means in practical terms, though, if you are a global business, and this is frankly how it actually works out at the end of the day, is it gets very complicated. Because what happens is there's a problem, and if the US, and we can all think of perhaps examples where the US might suddenly consider that they've got jurisdiction because it's on their doorstep or whatever, they determine there's a problem that they want to get involved in. It doesn't always have to be on their doorstep. They deploy long-arm jurisdiction when they want. They get involved, and then it turns out that because of other laws, whether it be the laws that we've touched on here, or some of the other laws, bribery being a good example, that other jurisdictions suddenly get involved. And so what happens is this is not a sort of a yes/no type scenario. Yeah. The scenario is, it's not like, yes, it's in the US, so we don't have to worry about it in the UK. I mean, I've been involved in numerous cases, and what you find is that you have different people in different jurisdictions all wanting a piece of the pie. And because the laws are all different, then it turns out that you've got completely different considerations in each jurisdiction. It gets very messy. And because even across the EU, Greece is very, very different to Germany, for example, in the way that they operate. That just the whole charging process is somewhat alien, right, to other jurisdictions, including the UK, but not just the UK. The time it takes is different. And so you end up in a scenario which just gets very, very, very messy, and frankly, one that you want to avoid. You want to do all that you can to avoid ending up in one of these things by sort of following some of the recommendations that I've touched on this call, so that you don't have to then face, okay, well, the position the US want to do this, this EU jurisdiction wants to do that, the UK wants to do something else, somebody else wants to do something else. Then you've got all of the, the fallout from the civil side, and it becomes a nightmare for donkey's years.
Yes. So we've got, I'm going to weave in a question here, but it builds into something that you mentioned earlier, Barry, and Paul, you might want to talk about this in the context of the shipping industry specifically. But as I say, you mentioned here about the sort of, I suppose, current ambiguity in regards to prosecutions and what enforcement may look like in regards to ECTA. And the question coming from the floor is in the context of the fact that there have been very few prosecutions under the Bribery Act due to lack of funding, etc. Do you think that will be a factor with ECTA as well? And are we just creating a bigger pool, if you like, of things that we have to look to enforce without the appropriate funding to be able to do it properly?
Yeah, well, I mean, I suppose my answer to the question is this. I think if you do snapshots, it's pretty unhelpful. If you look, and I think it picks on something that Paul said earlier, if you look at the UK position vis corporate criminal liability across the piece 15, 20 years ago, the answer was there wasn't any. If you now look at it, even with people snapshot, oh well, the SOA didn't do anything last year, it's a completely different picture. We have got Tesco's, G4S, Serco, Airbus, construction companies, oil extraction companies that have all reached resolutions with prosecution agencies. Recently, a gambling company that reached a resolution with the CPS. Rather than look at specific days, months, and years, I would look at trend. And trend is that it's gone from nothing to suddenly household names being on the receiving end of this sort of stuff and forging resolutions. So it is true that governments are underfunded. That cuts both ways as well.
Yeah.
If you listen to any speech that the new director, the latest director of the SFO, for example, gives, he weaves in how over the last 5 years they've made $2 billion for the Treasury. Not that it's a cash generating exercise at all, by the way, which, by the way, for a cynic like me, that's exactly what you think it is. And the truth is that he is not going to get that. He's only going to get $2 billion over the next 5 years or the next 2 years, whatever he's set himself his target as. He will deny he's got a target, of course, if he goes after corporations. Because at mom and pop or Ponzi scheme type frauds, the whole deal is, and there's been a lot of those in the last, since he started in October, I think he's done 5 sets of dawn raids on Ponzi schemers, but they don't have any money. The fact is it was never there in the first place. They take it all in, they give it to the new people through the door, they buy themselves a fancy house and maybe a sailing boat and maybe a villa somewhere. But beyond that, it's a fraction of the loss suffered by the populace. So there's no revenue coming in from that. The only revenue that's coming in is from big corporations who, as I referenced the pot of gold earlier, who either by dint of a bribery investigation or a fraud investigation end up on the hook and have to get the checkbook out.
So we're over time now, but indulge me, I've got 2 hopefully relatively short questions and then some summing up, I suppose. Number one, I think, Barry, you alluded to guidance anticipated from government, etc. Someone told me as I came into the office about an hour ago that City M had alluded to there may be an election called at some time soon, etc. Do you have a rough idea as to the timeline for the guidance, or is it?
Yeah, I mean, I'm sort of expecting it nowish. I mean, the reality. I was somewhat cynical. There's a 6-month stop clock, I think, from it being published to the fade to prevent fraud offence coming in. Bear in mind that I say, my recommendation is, should be doing it now, because half of this is already in, right? So I know that lots of people are going to be saying, oh, we'll wait for the guidance to come out. Anybody that's, read the previous guidance could write it already, to be honest, and there's going to be zero surprises in there. But I do think, an advanced draft, because of that reason, an advanced draft was circulating within weeks. I thought it was going to take months of the enactment, right? I do know that various industry groups have gone back with lengthy comments in relation to that guidance. The extent to which they are onboarded or not remains to be seen. But I would have, I would have thought summertime, basically. There's no particular. This obviously it got passed by the Conservative government. I don't think they may or may not be agnostic about what actually happens as a result of it. But I mean, it's a bit like when you have a transaction and you spend a long time negotiating the transaction. Here, there was a very long time spent arguing over what these offences were going to look like. But having signed on the dotted line, or in this case, enacted the statute, what follows next is largely driven by process and civil servants that won't really be that impacted by all of this. As far as the politicians are concerned, this is sort of done.
Yes,
there's not going to be a debate in Parliament about the guidance, I don't think.
So to sum up, and firstly, just to re-emphasise, this piece of legislation has been long in gestation and isn't a knee-jerk reaction to the sort of wanting to target Russian oligarchs, etc. I think it's fair to say it's largely bringing us up to standard with the US, and we're somewhere between the US and the EU regarding the strength of the legislation. Is that a fair appraisal of?
Yeah, I think that's a fair appraisal. Yeah. As I said, I mean, the US is very simple because it's just there's one standard and it's extreme of ours. The EU is a patchwork quilt, and some of it's good and some of it's bad. I mean, if for example you went to France, you can see there that they're on a similar trajectory.
Yes,
they've got an outfit called the PNF in Paris. They are investigating hundreds of cases. Their work rate is far in excess. They are to be commended, and they are very, very interesting corporations. If you go to other jurisdictions, in Germany's sort of slightly different picture, very complicated in relation to companies there to even charge them. But again, they do get their resolutions. So it gets very. What you can say is it gets very complicated and very, 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 very expensive to resolve. And what you do see in practical terms is there's a large dose of politics, I think, in all of this as well. This is politically unattractive for jurisdictions like the US to be fining, and most of their fines in relation to this sort of stuff do target non-US. Certainly when it comes to bribery, the list is 70% is non-US companies, and so it sticks in the craw, I think, of lots of jurisdictions when they start levying extremely large fines, and suddenly the non-US jurisdiction, home jurisdiction of the entity, is not levying any fines at all. So that's why you get all this bandwagon jumping, whether it be from Germany or quite recently the Netherlands or Paris and France, where they're also getting in on the act. And again, those governments are broke and they all want the revenue, to be blunt.
And I think to re-emphasise as well, and Paul, understanding what you were saying, it seems to me that at least there should be an expectation that the industry already has relatively sophisticated KYC processes, due diligence processes, etc., that include the risk assessment piece, the due diligence and the continual monitoring. And really what we should be looking to do is include ECTA within that suite of due diligence processes, if you like, and take the time to understand the legislation and understand what sort of exposure whether you're a UK entity or a foreign-owned entity that you may have. Is that a fair appraisal to sum up as a passing message for what those in the value chain should be doing?
Yes, and yeah, that's a fair assessment. I think just keep in mind, I mean, there will be, it does require some consideration and thought, because most businesses would say, well, we've got anti-fraud measures, we don't need to worry about any of that.
Yes.
But some of it is targeting them not being the victim of fraud, for example. It's not necessarily targeting losses being suffered by others. And so you just need to sort of recalibrate a little bit, or sort of refocus the lens, just to make sure that what you've got is, appropriate for this.
Yes.
And so, we've been talking to, I would say, numerous clients now about this new law, helping them with training and stuff like that, and just giving them some pointers or more if they would like it, just to help them out with this process. I mean, this shouldn't be, it doesn't need to be and shouldn't be a massive deal, but you only have to be unlucky and then not to have done some of the basics, and then it becomes a very big deal indeed.
Yes, on you personally, obviously, not just the corporate entity, which is the something.
Exactly. And as I say, because the individuals are the gateway to the pot of gold company that I've talked about, their risk profile, where once before a police force or the SFO or the NCA or HMRC or whoever it is that decides they want to sort of have a pop at this, they're now incentivized to go looking after those individuals in places where they weren't before, because they are a gateway to the pot of gold at the end.
I think I was going to add one final comment, and I think it sort of brings it back to the purely shipping context, and it's the ISM code, of course, and you can't go through the code and then just leave everything on the shelf gathering dust. You have to dust it off and have a refresh and have training, and I think that applies particularly in relation to this legislation, and I think that for me underlines what Barry has been talking about.
Well, that's so. I think Barry, you've done a great job at highlighting the legislation and providing an overview. I think as we've discussed, we've gone through the SPV piece and importantly where the UK nexus may reside. As we've just discussed, the mitigation strategies, etc. And of course, if you want further advice on that, then I'm sure Barry will be very happy to provide it to you. So I think all is left for me to do is to ask Paul, who is obviously a fundraiser par excellence for the Mission to Seafarers. Well, I should say Paul and his two Labradors. How are you going on your walk back from Australia?
Just
if that's right.
So actually, we've just Toby and Fenton turned 10 on Saturday, and we've decided to begin a new walk for the Mission to Seafarers. We're walking from Cape Town to Cairo, another virtual walk, 4,500 miles. I haven't quite worked out how long it'll take us, but it will be a long walk. Compared to the other walks we've done, it is, I think it's double the longest one we've done. But anyway, I think they would be quite proud of me, given the IT issues I've had. Perhaps I need to go for a long walk myself now. But,
yes.
It's been, but thank you for asking. It's a pleasure to support the Mission to Seafarers. I think it just reminds us actually that without seafarers, there is no shipping. They are the lifeblood of shipping, and it is such an important industry.
Paul, I think that's a very fitting place to end. And I should also apologise because I think we are at the mercy of the weather in the UK at the moment. And I've noticed that I was going into quite deep shade at certain points in the webinar and actually looking quite sinister. I promise it's due to the weather and not any other reasons. But I think on that note, I'd like to thank Barry and Paul very much for taking the time to speak with us today. Thank you to all of the attendees on the webinar. As I said, a recording will be sent to all of those who registered, and I think we will look to upload this onto our YouTube channel, etc., over in the next couple of days. And apart from that, all that's left for me to do is to thank you again and wish you a very good afternoon. Thanks again. Bye-bye.
Thank you.